matter of Global Guardians Management Ltd and others, and London Borough of Hounslow and others.
May it please you, my lord, I represent the appellants in these two cases, Global Guardians Management, Global 100 Ltd and Mr. Kyprianou. And I lead Mr. Pettit, who represented the appellants in the Upper Tribunal below. The London Borough of Hounslow is represented on my far right by, on your left, my lord, by Mr. Ranjit Bose, KC and Tara O'Leary.
Yes.
Mr. O'Leary. The occupiers, so the Spanish contingent, Mr. Jimenez, Sanchez and Morales, and Ms. Laleva, Mr. Green, Mr. Pidgeon, Mr. Ndanga, Mr. Lamani, Mr. Arkin, Miss...
In both appeals? I hadn't appreciated that. Mr. Bates, you're appearing for occupiers in both appeals,
I do. I have all the occupiers in both appeals, my lords.
Right. I thought it was just the Hounslow appeal. No, all right.
And Mr. Bates leads Mr. Penny.
Yes. Well, I can tell you that we have read the decisions of the first tier tribunal and the upper tribunal in both appeals, and we have read all the skeleton arguments. Ground one is the same in both appeals, and
right.
ground one is the only ground in the Jimenez appeal.
That's right.
So we thought that it might be convenient to hear both appeals together rather than one by one.
My lord, yes.
And I hope that between you, you have divided up the available time.
We have. Mr. Bose and Mr. Bates have agreed this, that Mr. Bates will make submissions in relation to ground one, and Mr. Bose might make some additional, but Mr. Bates will carry most of the weight in relation to ground one.
All right. So we'll hear Mr. Bates before Mr. Bose in that case. Yeah. All right.
And then finally, sorry, Mr. Bose and I invited Mr. Bates to sit in the front row, and I hope that doesn't offend you. Thank you, I'm obliged. I apologise, there's a plethora of bundles, and we've added to it this morning with a rather rudimentary bundle, for which I apologise. In these days of Adobe Acrobat Pro, what we've produced is a bundle with manuscript page numbers on it. If over the lunch and adjournment you want something that is tabbed and with hole punches, I can certainly...
We can read manuscript.
The manuscript is just the page numbers. It's hopefully everything else is photocopied appropriately. That bundle of additional material largely comes from the 2004 Act.
Yes.
There is a repeat. So the first four sections of it were produced as a result of me rereading the skeleton arguments and looking at the material. The last two tabs were produced by Miss O'Leary.
Yeah.
And section 255, we both considered that needed to be in the bundle. So obviously that's probably quite important.
Yes.
My lords, there are three issues on this appeal, all turning on the construction of provisions in the Housing Act 2004. The first issue turns on the construction of section 254, subsection 2D, and concerns what we've called the sole use criteria for the definition of houses in multiple occupation. I'll come back to that. The other two issues turn on the definitions in section 263 of the Housing Act 2004 of a person having control in subsection 2631, and also of rack rent, which is a part of the definition of a person having control. And that's in subsection 2632. And the second definition is a person managing, which is defined in section 2633 of the Housing Act 2004. I think there isn't much disagreement between the parties that the definitions in the Housing Act 2004 are not drafted with the absolute clarity. There is some difficulty in relation to constraining them, which is unfortunate given that they are definitions that can be part of establishing whether or not somebody is committed a criminal offence or not. What I propose to do, my lords, is take you through the statutory provisions first, if I may.
Yes.
So there's an authority, I'll start with the principal authorities bundle and tab 11. if you turn, my lords, to page 260, you will find there the definition of a house in multiple occupation. And Parliament considered it necessary to establish 3 tests for whether or not any premises are a house in multiple occupation. The standard test, which is under section 254, subsection 2, the self-contained flat test under section 2543, and the converted building test under section 2544. It's also right, and we'll come to section 255 in a moment, that a local authority, a local housing authority, which has the responsibility for enforcement of the provisions in relation to houses in multiple occupation, can make a declaration that any particular premises are to be treated or regarded for the purposes of the Act as a house in multiple occupation. I think we really only need to, for these purposes, because the relevant provision that we're concerned with in this case comes in section 254, subsection 2D, we only really need to have a look at subsection 2542D. So subsection 2542 contains 6 criteria or requirements that are necessary to be satisfied for any building or part of a building, and in due course that might become part of the matters upon which you, my lords, will receive submissions, meets the standard test of being an HMO. So subsection 2A, it consists of 1 or more units of living accommodation not consisting of a self-contained flat or flats. Living accommodation is not defined in the Act. B, the living accommodation is occupied by persons who do not form a single household. Section 258 provides some clarity as to what that means. For these purposes, we don't need to look at section 258. (2542)C, the living accommodation is occupied by those persons as their only or main residence, or they are to be treated as so occupying it, and that's clarified in subsection 259. Subsection D, their occupation of the living accommodation constitutes the only use of that accommodation. That's the section that we're going to be concerned with in due course. Subsection D does not say, or does not make clear whether that occupation has to be occupation in accordance with subsection C, i.e. that it's their living, that it's their residence. So it's residential occupation. It just says their occupation. E, rents are payable or other consideration is to be provided in respect of at least one of those persons' occupation of the living accommodation, and 2 or more households who occupy the living accommodation share 1 or more basic amenities, or the living accommodation is lacking in 1 or more basic amenities. For these purposes, it's accepted that in both these cases, basic amenities were shared between the people who occupied the buildings. The basic amenities are effectively cooking facilities, washing, and toilet facilities. Section 255.
Section 254, subsection 3, B, substitutes references to the flat
Yes.
in place of references to the living accommodation. So that looks as though it's a little bit broader than 2542, which concentrates on their occupation of the living accommodation.
Yes.
Yeah.
But so a self-contained flat may very well contain all of the basic amenities, but if they're being shared, then by people who do not form more than one household, then it will necessarily be an HMO. But it isn't clear why it's necessary for there to be a separate self-contained flat definition, because a self-contained flat presumably is part of a building.
Well, except that A talks about not consisting of a self-contained flat or flats.
Yes, it does. But if you took away that part of it and you said it consists of 1 or more units of living accommodation, a flat would be a unit of living accommodation, presumably, or it could be divided up into different But a separate definition has been introduced for under 254.
And sorry to interrupt, is there a definition of households?
There is a definition of people who form a single household. In effect, it's not being related to one another.
Right. So it's, if they sign at the same time on the same tenancy agreement, for example, in a two-bedroom flat, they'd still be separate households.
Yes. Section 255 has been put in your supplemental bundle of authorities. And it's at page 12, starts on page 12 and goes to page 14. And it provides for HMO declarations. If a local housing authority is satisfied that subsection 2 applies to a building or part of a building in their area, they may serve a notice under this section, an HMO declaration, declaring that the building or part to be a house in multiple occupation. Excuse me, subsection 2. This subsection applies to a building or part of a building if the building or part meets any of the following tests as it applies without the sole use condition. The standard test, so that's the one we've been through.
Yeah.
And then at the bottom of that, subsection 2, and the occupation by persons who do not form a single household of the living accommodation or flat referred to in test in question constitutes a significant use of that accommodation or flat. So you can see that Parliament must have assumed that the sole use condition does exclude some premises because it gave local authorities the capacity, the power to make a declaration that notwithstanding that the sole use criterion is not satisfied, if you're close to satisfying the sole use criteria, you can make a declaration making the property an HMO. That causes some conceptual difficulties when one considers that under the standard test of a house in multiple occupation, a building or part of a building meets the test. So what is the purpose of allowing local authorities to make a declaration in these circumstances? We know that in neither of these cases did, in the Hounslow case, in the appeal in which the London Borough of Hounslow is involved and in which a financial penalty notice was served, the local authority did not consider making a declaration in relation to...
Is it really all that mysterious? Couldn't you have, as your unit of living accommodation, you could be both using it as your residence and conducting your business from there?
But you're still in occupation of it.
Yes.
So in those circumstances, what the sole use exception excludes would be live-work units, as an example.
Why? You just told us that it's occupation, not necessarily residential occupation.
Well, I say it. My Lord Singh's question was the exclusion would be if somebody was also working in their living accommodation.
Yes. So you're running an online business from your bedroom.
Yes.
But you said when we were looking at section 254 that D is only concerned with occupation,
Sorry,
not with residential occupation.
Sorry, I didn't intend to make the submission that it's only concerned with occupation.
Oh.
What I said, my lord, was it doesn't make it clear whether the occupation is residential occupation under 2542C or not, whether it's any occupation.
I see.
When you read the provisions as a whole, isn't it tolerably clear that in paragraph D it does mean your occupation because it's your only your main residence, and then the reason why Parliament may have wished to allow for declaration by a local authority under 255 is to cater for the kind of situation that I've just posed to you, which is where, as well as being your main residence, or your only residence, it's also where you conduct your business from.
My lord, yes, and certainly that supports our case in relation to the sole use argument on this appeal, because we say that the guardians were also working. So we would say that read as a group of conditions, it is pretty clear that the occupation means residential occupation in 254D.
Sorry to interrupt, just to clarify, when you say working, we know they were working, some were working as teachers, some were working things. When you say working, you mean working as guardians?
They were also performing their functions as guardians, yes.
So that's what you mean as working, rather than working.
Yes, that's sorry.
Yeah.
Yes.
No,
Yeah, absolutely.
I just want to make sure I got it accurately. Sorry.
Yeah, no. If they're working elsewhere, then clearly that isn't part of their occupation of the premises. But if the idea is that that section 2542D excludes live work units, for example, then we would say we fly under we sort of come in under that wing. Section 260, my lords, on page 263 in the main authorities bundle. You'll see there's a presumption that the sole use condition or significant use condition is met. So in effect, the burden is put on the party saying that this is not a sole use building. Then if I could ask you, my lords, to turn on to page 266 in the authorities bundle, we get to the definitions of person having control and person managing, etc. Sorry, before I apologise for taking this out of order, but on reflection, it strikes me that this is probably the best way of doing it. We've got the definitions of HMO. We can then have a look at the requirements to licence. And then we'll come back to the other definitions. So in the additional bundle of authorities you've been handed up, at page 10 is section 55 of the Housing Act 2004. When the Housing Act 2004 came into force, it did not of itself, without statutory instrument, require any licensing of HMOs. So it established a regime whereby the Secretary of State was going to promulgate statutory instruments which would set out what HMOs had to be licensed. So section 55, which is on page 10 of that additional clip that was handed in this morning. Section 55, licensing of HMOs to which this part applies. This part provides for HMOs to be licensed by local housing authorities where they are HMOs to which this part applies, see subsection 2, and B, they are required to be licensed under this part, see section 61(1). Subsection 2, this part applies to the following HMOs in the case of each local housing authority. Any HMO in the authority's district which falls within any prescribed description of HMO. And then the local authority has power to make additional licensing regulations in its own area. So it could say any HMO that satisfies the requirements in this borough have to be licensed. At the front of the, page 8 in that bundle, you have the first statutory instrument that was issued in 2006 relating to the licensing of HMOs, and it was called the Licensing of Houses of Multiple Occupation, open brackets, prescribed descriptions, close brackets, open brackets, England, close brackets, order 2006-371.
Yeah.
And you'll see it, what you have there is Article 3, that's been superseded, and we'll come to the 2018 provisions in due course. They're at the front of that bundle. But you'll see there that Article 3, sub-Article 2, the conditions referred to in paragraph 1 are that the HMO or any part of it comprises 3 stories or more, it is occupied by 5 persons or more, and it is occupied by persons living in 2 or more single households. So not all HMOs were required to be licensed. And you might say that those initial requirements in relation to licensing would have allowed quite a lot of smaller HMOs to fly under to not be required to be licensed by statutory instrument. So even insofar as it's going to be said, well, this was all to control substandard accommodation, in 2006, when these prescribed licensing requirements were first introduced, you might think that they weren't going to be very comprehensive, and they were only going to apply to HMOs of more than 3 stories. Sorry, 3 stories or more, I apologise. So provided you kept your HMO to 2 stories, you were all right. You didn't need a licence. And they needed to be occupied by 5 or more persons. So 4 or fewer, you were okay. They were superseded, my lords, by the 2018 regs or order, and that's at pages 2 to 7. Article 4 is the relevant article for these purposes, and it starts on page 3. It's right at the bottom of the page, my lords, and you'll see that the need for 3 stories or more was removed, but otherwise it remains the same.
So it's still 5 people.
Still 5 people. Yeah.
So if you go back to your 2-bedroom flat with 2 separate people signing on the same tenancy, then you don't need to license because it's not 5.
Provided they're the only 2 occupants, yes. Unless, of course, the local authority has issued a rule in their a rule in their area that all HMOs have to be licensed. So if we go on, my lords, back to the main bundle of authorities and pay section 263, which is on page 266. This defines, for the purposes of this Act, persons having control and persons managing, and they're relevant because they are the categories of people who might be subject to rent repayment orders, financial penalty notices, and criminal liability. So subsection 1, 2631, in this Act, person having control in relation to premises means, open brackets, unless the context otherwise requires, close brackets, and I think we accept that in these circumstances that the context does not otherwise require. The person who receives the rack rent of the premises, whether on his own account or as agent or trustee of another person, or who would so receive it if the premises were let at a rack rent. And then 263 subsection 2. In subsection 1, rack rent means a rent which is not less than 2/3 of the full net annual value of the premises. My learned junior and I have been wondering why parliamentary draftsman included the reference to rack rent. We have wondered whether or not it was just because that was borrowing provisions from previous statutes. I apologise, I need to find the reference.
You've given us one in the authorities bundle, one of the previous statutes. It goes back quite a long way, as Mr. Justice Fancourt pointed out.
Yeah.
You've given us the Public Health London Act 1891.
Yeah, no, that's right. But in one of the authorities in the bundle, I thought I tabbed it.
Holway, I think Lord
Yeah,
Bridge says
Holway,
it goes back a
very
long
grateful.
way.
Apologise. I think it's Lord Bridge.
It is, it's Lord Bridge in Holway.
Yeah, Lord Bridge and Holway. Page 89 in the authorities bundle, my lord. Page 95 of the judgment, Lord Bridge, at D to E.
Yeah.
The truth, I suspect, is that generations of parliamentary draftsmen have been content to use the time-honoured formula without ever contemplating its application to the circumstances presently under consideration. But they did think about it enough to say that the rack rent was 2/3 of the net annual letting value.
What does net mean? Net of what?
My lord, taxes, council tax and poll tax and other tax, not poll tax, sorry, taxes that fall due to be paid on the property.
Repairs?
Well, I'm sorry, I haven't, apologise. So turning back to page 266 in the authorities bundle. And then at subsection 3, we have the definition of in this act, person managing means in relation to premises, the person who being an owner or lessee of the premises, A, receives whether directly or through an agent or trustee, rents or other payments from, one, in the case of a house in multiple occupation, persons who are in occupation as tenants or licensees of parts of the premises, and going on to B, would so receive those rents or other payments, but for having entered into arrangement, whether in pursuance of a court order or otherwise, with another person who is not an owner or lessee of the premises, by virtue of which that other person receives the rents for other purposes, and includes where those rents or other payments are received through another person as agent or trustee, that other person. So you'll see that Mr. Justice Fancourt, in the Upper Tribunal decision in the Hounslow and Lewison case, decided that there was no evidence that G100 was acting as an agent or trustee for GGM, and therefore that G100 there was no evidence that G100 had a lease, and therefore that G100 could not be a person managing.
Is there an explanation for why the definition of person having control refers to the rack rent, whereas in relation to the person managing, it can be rents or other payments?
My lords, we haven't found anything that was considered by Parliament whilst the Act was going through or was issued by Parliament. There is in the supplemental bundle, apologise, that the Council for the London Borough of Hounslow at page 16 have produced explanatory notes in relation to section 255, which of course don't help in relation to section 263. In London Corporation Cusack and Smith, which is tab 2 of the authorities bundle, my lord. which concerned the Town and Country Planning Act 1947, pursuant to which, where an owner of land had applied for planning consent to redevelop their land to build on it, and was refused consent, they could serve notice on the local council requiring the local council to purchase the land. In that case, Cusack, Smith and others had applied for planning consent to the London Corporation, who had refused consent, and then served notice requiring the London Corporation to purchase the property. And the issue was whether or not Mr. Cusack, Smith and others were the owner, as defined in section 1191 of that Act. Section 1191 in that Act said, except so far as the context otherwise requires, owner in relation to land means a person who is entitled to receive the rack rent of the land, or where the land is not let at a rack rent, would be so entitled if it was so let. Lord Reed, whose judgment is one of the judgments of the majority, discussed this issue from page 358, page 37. From a bit earlier, I apologise. His discussion really starts at page 36, two-thirds of the way down. Ownership within the meaning of the definition depends on whether or not a person would be entitled to receive the rack rent. He posits two circumstances, one in which the property is not let at all, in which case the owner, the freehold owner, is the person entitled to receive the rack rent, because they could let it as a rack rent. He then posits a situation where there are a lease or a series of leases, and considers whether, if one of those leases is at less than the rack rent, who is entitled to receive the rack rent. And his conclusion, starting on the highlighted page, page 38 in the bundle 359 of his judgment, my lords, starts with the second limb of the definition, appears to me to be more obscure. What my lords, Lord Reed concludes is that in these circumstances there can really only be one person who's entitled to receive the rack rent. Although he does recognise that where a head lessee is paying the rack rent at the time that his lease was entered into, and another sublessee is also paying the rack rent at the time that his lease was entered into, they are both entitled to the rack rent, or they're both in receipt, I apologise, they're both in receipt of the rack rent and therefore satisfy the first limb of the definition. I apologise, they don't both receive, they're both paying the rack rent. However, where you have a situation where the head lessee is not receiving the rack rent, then the sublessee, subject to their lease not having any conditions on it, would be the person who is entitled to receive the rack rent. At page 360, my lords,
why do you say subject to any conditions?
Well,
this is a hypothesis. You hypothesize a letting at a rack rent, and then you ask yourself, well, if that hypothesis were the fact, who would get the rent?
my lord, yes.
And normally, when you've got some sort of valuation hypothesis like that, you disregard personal restrictions which might cause the hypothesis to be inapplicable. So the mere fact that you've got a lease which says you can't sublet wouldn't stop the court from concluding that if it were to be sublet as a rack rent, you, the sublessee, would collect the rent.
Well,
surely.
my lord, I don't accept that proposition. If you turn on to page 360, my lord.
360. Yeah.
360. It's the very last paragraph or sentence, really, sentences of the highlighted indicated passage.
Right, so Lord Reed doesn't decide that.
No doubt there could be a case where he doesn't decide it. No, tenant or subtenant in possession of the land is effectively prohibited from subletting.
And what does Bowditch, how does Bowditch solve it?
Well, my lord, I must confess, when I read Bowditch, I found it very difficult to see how it did solve that problem. We don't have Bowditch in the bundle. But my lord, if a tenant has a restriction on not being entitled to themselves sublet their property, in my submission, then in those circumstances, they can't be entitled to receive the, even though they are in occupation, they can't be entitled to receive the rat rent if the property is let.
Yeah, well, I was thinking of cases like Inland Revenue Commissions and Crossman, where you're trying to value shares in a private company which are subject to all sorts of rights of preemption, fixed prices.
Oh, yes.
And the House of Lords says, well, you disregard restrictions on selling the shares, but any purchaser will be bound by the same restrictions, and then you have the price. Because you've got to make the hypothesis work.
But what we're interested in establishing here, in effect, is who is entitled to receive the full value of the property.
Yeah, for the purpose of enforcing housing standards.
Absolutely,
You
and
can't have a situation, as Lord Justice Denning pointed out in Rawls, where nobody's responsible.
no, my lord. If the lease which is subject, sorry, in my submission, if the lease which is subject to the restrictions is not entitled to receive the rat rent, then the next person up the chain is entitled to receive the rat rent if the property was let at a rat rent.
Well, that's directly contrary to what was held in LCC and Cusack Smith, isn't it?
In my submission, it's that person whose right of occupation is is not restricted in relation to granting the rat rent. And in my submission, it's consistent with the Polway decision, in that the freeholder in that case was entitled to the rat rent, but all of the lessees who had the immediate right of occupation of their flat were, and their flats were not subject to any restriction on subletting. My lords, I'm not sure I can help you any more with that.
All right.
If I could now deal with the way in which the London Borough of Hounslow approached the case in which it is involved. It clearly served financial penalty notices on Global 100, on GGM, but also on the NHS property services. We know that they served one on the NHS Property Services Limited because Mr. Justice Fancourt deals with that, or records that. Paragraph 83 at page 65 and 66. Of his judgment, which is on tab 4 of the core bundle in the Labour and Hounslow case.
Sorry, which page?
65 and 66.
65.
So it's paragraph 83, starts at the bottom of page 65 and goes over to page 66. So,
Yes.
so in my submission, the approach that the London Borough of Hounslow took could be described as a Gattle-gun approach. It didn't really mind, or it served notices on both G100 and GGM on the basis that they were both persons having control and persons managing. We don't know the basis upon which it served the notice on the NHS, but we know that it did serve a financial penalty notice on the NHS as well. In the Upper Tribunal, the approach to the first issue, so the issue of whether or not, in this case, the approach to the sole use condition in the Lelaver case was dealt with by the first tier tribunal at paragraph 102, which is at page 133, my lords, in your core Lelaver bundle. At Stamford Brook, the units of accommodation are the individual rooms occupied by the guardians. Even though they did not have exclusive possession, they did have exclusive use of their rooms. They had keys to their rooms. The guardians occupied their rooms as their residences. The tribunal is therefore satisfied that their occupation of the living accommodation constituted the only use of that accommodation, and that the conditions specified in section 252D is met. So if I could summarise that, the tribunal was operating on the basis identified by my Lord Singh, that occupation for the purposes of section 2542D means residential occupation. It took the view that the living accommodation was the rooms, and it applied a test of the position on the ground rather than having regard to the contractual obligations. On that basis, even if the licences effectively had been work-live licences, the tribunal would have, in my submission, come to the same result and not had regard to the terms of the contract. In the Jimenez case, the first tier tribunal decision is at tab 8, my lord, starting on page 71. And the first issue, the sole use issue, is dealt with at paragraph 45 on page 78. It is submitted that the applicants were property guardians and their occupation was not to provide accommodation but rather protect the property. The tribunal rejects this contention as wrong. The applicants were not service occupiers or otherwise employed to protect the building. A side effect of their presence may be to dissuade trespass or damage, but they were there in order to have a roof over their heads and only that. So the first tier tribunal in Jimenez looked at it from the perspective only of the occupiers. And made a distinction between a use and a purpose. In effect, saying.
Is that right? I thought they were drawing a distinction between use and side effect.
It uses the word side effect. I accept that, but one might say that a side effect is a purpose.
Yes.
Why? Why would a side effect be a purpose?
My lord, I accept that. I agree that I was being over generous to the first tier tribunal in saying that they were finding it was a purpose. I was sort of fitting into my scheme of thinking about things. Yeah, they said the first tier tribunal merely found that it was a side effect. So they had no regard to the purposes of the NHS, of the owner of the property in that case.
But purposes are not within the statutory definition. Statutory
They're not.
definition talks of use.
It does. I accept that. And our argument is, in relation to this first issue, that a purpose is a synonym for a use, and that where there is more than one purpose in the occupation, that takes the, or that causes the sole use exception to be engaged, and therefore that where people are in occupation for the purposes of work, like in a live-work unit, or to provide a service to the person who's allowed them into occupation, protect the premises, that is another use of the premises.
Well, it might be said that a use is how you use something and a purpose is why you're using it. So if you take a car for a test drive, you're driving it, that's all you're doing with it.
Yes.
Why are you doing it? Well, your purpose is to test it.
It might very well be said, and I can see that and I accept that there might be a single use that has more than one purpose, and I also accept that a use indicates something that might be active, like driving the car, and the purpose might be something more passive, such as finding out if you like it. I accept that.
But anyway, you say that use is the same as purpose in this context.
We do. Or what we say is, it isn't simply the perspective of the occupiers that one must look at. One must look at the extent to which their occupation is also performing another purpose, and that in that context, purpose is synonymous with use.
Can I just ask how far you take that? Suppose I rent you a flat in London so that you get experience of London and you are just living in the flat. Does that, the fact that my purpose is that you learn a bit more about London, mean that that is also a use of the flat?
So, in my submission, unless one would need to look at the contractual arrangements between us to see whether or not
Maybe no contractual arrangement, may just be sort of fatherly sort of provision.
Yes. Well, in my submission, that would be another. It would be another. The fact that you were helping me obtain experience of living in London would also be a use of the flat. Yes.
Thank you.
Because in the Hounslow and the Labour case, Mr. Justice Fancourt largely accepted the analysis of Martin Roger in the Jimenez case. We really need to look next at the position on the appeal to the Upper Tribunal in the Jimenez case in relation to issue 1.
Yeah.
Martin Roger starts his analysis, my lords, at paragraph 38, which is on page 39 in the core bundle in the Jimenez case. Mr. Pettit referred to a definition of the noun use in the Oxford Dictionary as inter alia application to a purpose. A use, he suggested, was a purpose that was being applied. Use and purpose were therefore synonymous, and where an arrangement provides more than one purpose, once the arrangement was applied, it would involve more than one use. So my learned junior relied there on the Oxford English Dictionary definition of use and purpose, purpose as being synonymous with use. Paragraph 40 from paragraph 44, Mr. Justice, sorry,
I
Martin Roger
don't quite understand why the dictionary supports the proposition that use and purpose were synonymous. Use is the application, and the purpose is the reason why you're doing the application.
Yes.
So, I mean, so simply just reading the dictionary doesn't get you to a
Listen.
position where use and purpose are synonymous, does it?
Well, it provides purpose as a synonym
Does it?
for use. But if as nouns, the dictionary does say that one of the synonyms for use is purpose.
Well, it doesn't. It says application to a purpose. It's not saying purpose is the same as use.
No.
No, I'm driving the car. That's my application of
Yes.
what I'm doing. And the purpose is I'm taking it for a test drive.
My lord, yes. Paragraph 45, my lord, Martin Roger KC explains why he is not persuaded by the argument that the linguistic argument that use and purpose mean the same things. You'll see, my lords, paragraphs 41, sorry, paragraph 39, Mr. Pettit relied on the Ludgate House case. My Lord Lewison, you'll be familiar with that case. It's a decision of yours on rating and related to the consideration of whether or not, or of what was the primary purpose for which premises were being used, and who was the primary occupier. In that case, it was necessary to look at a hierarchy, if I could put it like that, of different occupiers, people in possession, in different levels of possession, and decide which one of them was the party liable for rates. In this case, it isn't necessary to establish a hierarchy. If there is more than one use, then the sole use exception applies. So it doesn't matter if the other use is de minimis. If it's de minimis, you might say it's not use, but it doesn't matter if it's not very significant. For paragraph 45, my lords, Martin Roger KC, starting 7 lines down from the bottom, it would be anomalous if statutory protection from poor housing standard depended on the fine print in the contract between the person in control of the property and the occupier. There may, of course, be cases where the contract creates a different type of relationship, such as that of employer and employee. But for the purposes of the sole use condition, the focus even then would be on the use which was actually being made of the living accommodation. And my submission there is that Martin Roger there falls into the danger of considering the use on the ground rather than any contractual rights. So, for example, if we had the live work units.
So wait a minute. So you say that he was wrong to limit consideration to the use on the ground.
Yes. So in my submission, they fall that both of my learned friends, or all 4 of my learned friends, fall into, is saying that what you don't look at the contracts about the occupation of the building in terms to determine what the use is, because in my submission that would create the situation where, and using the live work example again, an owner of a building grants rights of occupation of live work units that have shared facilities. But if everybody chooses not to do any work there, the position on the ground is that their sole use would be their residential occupation. And that would mean that a party that had not intended to create an HMO would be bound by this bound by this legislation and would have created an HMO and would be subject to potential criminal liability.
Well, it depends, because live work can mean live and or work, or live or work, etc. If you had made a requirement that they do work there, then that would be different. If, on the other hand, you just described it as live work, it might mean anything to anyone.
No, I accept that. If the licenses or the tenants, the requirement to occupy said that you must live and work, but people chose not to work there and work elsewhere, the arguments on behalf of the respondents is, well, you don't look at the fine print, you don't look at the contract. And I'm not sure I understand what the fine print in the contract is, but so it can't just be determined by what is happening in practice.
Is that what the Upper Tribunal is saying in that passage? Is it saying that you have to ignore the contractual provisions, or is it simply saying that they're not conclusive and that you have to look at everything, including the use on the ground?
Which is what Mr. Roger went on to do in 47.
He did. My lord, yes. So my submission is that the respondents in this case, skeleton arguments, have taken Mr. Rogers' argument and sort of extended it to a position of you don't look at the contractual obligations at all. And my submission is that that is wrong. The starting point should be what was contracted for. And in the circumstances of these guardianship arrangements, but for the owner of the property wanting the premises to be protected, these premises would not have been available for any sort of occupation, let alone residential occupation. And in those circumstances, in my submission, the use that the owner wants made of the property for the purposes of protecting their property is a relevant consideration. Paragraph 51, my lords, at page 41 in the Jimenez core bundle. So that's tab 4, page 41, paragraph. If I could start with paragraph 50, Martin Rogers, the Deputy President, does say that the statute purpose underlying the sole use condition is not immediately obvious. And in my submission, that might be an apposite observation. The presumption of the sole use condition in 260 and the power of a local housing authority effectively to disapply the use of condition by making an HMO declaration under section 255 suggests that a desire to limit the practical significance of that condition. I accept that that is right, but it also indicates that Parliament thought that it must have some effect and didn't have no effect at all. Because why give the local authority power to disapply it in circumstances in which it has no effect? Again, he was not referred to any material which suggested an explanation of the policy underlying the condition. At paragraph 51, he gives an example where he says that the exclusion might apply. And that starts 6 lines down from the top on the right-hand side. If a house consisted of 4 rooms with shared kitchen and bathroom facilities, 2 of the rooms being let to residents for whom it was their only or main residence, and the remaining rooms being used by the landlord for provision of bed and breakfast accommodation, it would be likely that the living accommodation would probably be treated as having more than one use, and in consequence that the sole condition would not be satisfied. But the definition of an HMO includes part of a building. And so you don't have to include the bits of the house that are let as a B&B. And so in those circumstances, the sole use condition would not have any impact.
So it would not have any.
Impact.
Because the living accommodation would be separate for each of the 4 separate people.
Well, it could be separate for the 4 separate people, or it could be the 2 rooms that are occupied by the members of staff.
Well, you might imagine something like an Airbnb where different people are let into, not Airbnb, because that wouldn't be sole residence, but an arrangement where people are let into occupation. They occupy the rooms as their sole residence, but the owner keeps some of his possessions in a locked cupboard in the room. You might say, well, part of the room is being used by the owner for storage.
Yes.
And the other part is being lived in. So that might be, you might say, in that situation, the sole use condition was not satisfied.
Right. So the provisions can be. Isn't the response to that is that the locked accommodation isn't part of the living accommodation because people aren't living in it,
Well, maybe.
and it's part of a bit. And in any event, excluding the locked cupboard, it's.
Just going back to paragraph 51, the passage you read to us, the final
Yes.
6 lines, I think what the judge had in mind there, of course he will have understood that the definition includes part of a building. But I think what he was emphasising was that although the 2 individual rooms may be used only by these people, whereas the rest of it is a B&B, that they would still be sharing the kitchen and bathroom facilities. So I think what he's envisaging is that the living accommodation includes the shared kitchen and bathroom.
Yes. And so it's a necessary requisite of premises being an HMO that some of the basic amenities are shared.
Mm.
Yeah, so that has to be the circumstance.
Yeah.
And I accept that the part of the building that would be an HMO, if you were dealing with it as part of a building, would include the shared facilities.
Exactly.
Yes.
So I think that's the situation he has in mind there.
Right.
So you can't just say that the relevant part of the building is just the bedroom of these individuals.
So my lords, I hear your distinction between purpose and use, and I accept that that is an interpretation that is open to the court in relation to the first issue in relation to use, and really I don't have any more to say about that. So if I can move on to issue 2. And that our submission is that Global Guardians Management is not a person managing the HMOs in this case, and it requires the person to, because it requires a person. The definition of a person managing requires that person to have a lease or to be an owner. And this only arises in relation to the Hounslow case.
Yeah.
And so we can put away the Jimenez bundles and move to the first tier tribunal decision in the Hounslow case. And that was really dealt with in my submission at paragraphs 104 to 120. And they start on page 134, which is on tab 8 in the the Laver, Hounslow, 4 bundles. The first tier tribunal very kindly has given us a heading, issue 3, the person having control on managing the building. You'll see there that the first tier tribunal really followed the approach of the London Borough of the Gatling gun approach of the London Borough of Hounslow, which was, we're not really bothered with working out which is which, and we'll just deal with them together.
Although it is fair to note that that was how Global 100 and Guardian Management conducted their business on the ground.
You might say that their evidence in that respect was unsatisfactory, absolutely. But, my lord, this does create criminal liability.
I understand.
And it may be that the first tier tribunal is not the best forum for defendants to be allowed to defend themselves against what are in effect matters that must be established beyond reasonable doubt. But I do accept, my lords, that it's clear from the transcript of the first tier tribunal that the tribunal was less than satisfied with the evidence that was given on behalf of my clients. So if you turn over to the page 135, you'll see there at 109, paragraph 109 near the top of the page, Hounslow's case is that both GGM and G100 are persons having control and persons managing Stamford Brook. Little one, they are persons having control as they are in receipt of the rack rent from Stamford Brook. Hounslow contend that the monthly licence fees totalling some £15,000 received from the Guardians as a rack rent, even where the Guardians to be licence fees, the term rack rent should be construed accordingly. You'll see in our submissions we say it's licence fees, not rack rent. We're not going to pursue that point. We accept that rent would include licence fees for these purposes. I'm sorry, I'll move on because I'm dealing with issue 2, I apologise. 109, little Roman 3. Alternatively, in the event the tribunal is satisfied that GGM was a lessee, GGM and or 100 would be a person managing Stamford Brook, as they were receiving payments from the Guardians. In determining whether it was GGM or G100 who was the person managing Stamford Brook is necessary
Sorry, where were you reading from, Mr. Grundy?
I apologise. Paragraph 109
109.
on page 135,
Yes.
little Roman 3.
Yes.
And that is how the first tier tribunal dealt with issue 2, which is it's finding that both GGM and G100 effectively had leases, or that G100 was an agent or trustee for GGM.
Yeah.
Alternatively, in the event the tribunal is satisfied that GGM was a lessee, GGM and or G100 would be a person managing Stamford Brook as they were receiving payments from the Guardians. In determining whether it was GGM and or G100 who was the person managing Stamford Brook, it is necessary to analyse the contractual relationship between GGM and G100. Hounslow argued that their relationship was so confused that both were in fact persons managing the property.
Yeah.
The analysis of this really, you'll see at paragraph 110, the first tier tribunal goes back to section 2631, dealing with a person having control. At paragraph 111, the status of a person managing is more restrictive. The relevant person must be an owner or lessee, while section 2624 provides that a statutory tenant is to be included as a lessee. There is no suggestion that this would extend to a licensee. Paragraph 115, the tribunal says the tribunal confirms Hounslow's decision that both GGM and G100 are persons both controlling and both having presumably having both control of and managing the HMO at Stamford Brook. Paragraph 116. First, we are satisfied that both GGM and G100 are persons managing Stamford Brook as lessees who are in receipt of rent or other payments from the Guardians. We are satisfied that National Health Service Property Limited granted GGM an interest in land, see 75 above. We'll go back to 75 in a moment. We find it impossible to accept that the substance and reality of this arrangement was a service agreement whereby Global Guardians would manage Stamford Brook on behalf of NHS PSL. In such circumstances, there would have been a direct contractual relationship between NHS PSL and the Guardians. NHS PSL accepted no responsibility to convert Stamford Brook for residential occupation for the subsequent internal maintenance of the building or for the health and safety guardians. So that is really the basis upon which the first tier tribunal in my submission finds that the agreement between the NHS PSL and GGM created a lease. You'll see, because in paragraph 117, they say, were we to be wrong on this, NHS PSL would be the person managing Stamford Brook as it was receiving rents or other payments through GGM as an agent. We are satisfied that finding NHS PSL was the appropriate licence holder would not reflect the substance and reality of the Guardian scheme agreed by NHS PSL and GGM. So in effect, what the first tier tribunal does there is it doesn't have any really regard to the statutory definitions of what a person managing is, but just decides that, well, looking at this arrangement, we think that the most culpable parties for establishing this HMO are GGM and G100. If we turn back to page 75, which is on paragraph 75, apologise, which is on page 125, my lords, of the judgment.
Don't we have to start at 69?
We do, my lords, yes. So, my lords, there is a analysis in I accept of the property protection proposal by which the NHS contracted with GGM for GGM to provide guardians for Stamford Brook. What the appellants say about this, my lords, is that the first tier tribunal and indeed the London Borough of Hounslow had to be satisfied beyond reasonable doubt that a lease had been created. And we know that in the county court, in the Global 100 and the Labour possession claim, His Honour Judge Luber found that the agreement between the NHS and GGM was a licence.
Did he?
He found it was a head licence, my lord, because he said...
He was concerned with the question whether there was an arguable defence.
He was.
And that was all he was concerned with.
He
And
was.
he said there was.
He said there was an arguable defence, my lord, yes.
And he was reversed on that. But I don't recall Judge Luber. I don't think we've got Judge Luber's judgment, have we?
You have, yes.
Where do I find it? I was looking for it this morning and couldn't find it.
Oh. So in the authorities bundle, there's a set of tabs that start at 1 again, and it's tab 2, and it's page 198.
What? Oh, yes. Yes. Right, let's see what he did say.
So it's a paragraph 50. So paragraph 50, which starts at page 206, my lords.
Yeah.
So which specific passage do you rely on?
So paragraph 51, my lord. Further, it was clear from its own terms that the licence granted on the 1st of October 2020 by NHS PSL was either parasitic upon or a mere extension of the licence earlier granted by NHS PSL to GGM, rather than any new freestanding agreement. I see no reason in principle why, if the parent licence agreement is to be treated as sub-licensed by the intercompany agreement, its offspring licence should not also be treated as sub-licensed. So in effect, what he's saying is that there's a series of licences, not a tenancy out of which licences were granted. Now, I accept, my lord, that it was unnecessary for him to make a decision as to whether or not there was the agreement between NHS and GGM was a lease or a licence. I accept that.
So when you quote Lord Keith in Arnold saying it's got to be a necessary issue, that doesn't raise any sort of estoppel. You're relying on it for a different purpose, are you? Saying, well, if Judge Luber thought it was arguable, then nobody can be satisfied beyond reasonable doubt. Is that the
My lord, yes.
But Judge Luber was looking at the case on the basis of some written evidence, perhaps. He didn't hear evidence.
No, he didn't.
So why can't the FTT say, oh, we've heard the evidence, and on the basis of the evidence we are satisfied beyond a reasonable doubt this was tenancy. We know, don't we, from the terms of the written agreement that there was a term and a rent, so we're only concerned with exclusive possession.
Yes. So the intercompany's agreement between, in the Labour case, sorry, not the intercompany's agreement, the original licence in the Hounslow Labour case is at tab 1 in the supplementary bundle. It's at page 203.
Supplementary bundle page?
It starts behind tab 1, but it's
Yes.
paginated as page 203, my lord.
Mine's,
And it goes to page 217.
mine's not, mine's paginated from page 1 onwards, but anyway.
Is that the property protection proposal?
Yes, that's right.
Yeah, we have it as page 1.
Yeah.
My lords, I accept that the FTT heard evidence and had a copy of this agreement in front of it. His Honour Judge Luber also had a copy of this agreement in front of him, and the argument on behalf of Miss Leleva was that G100 was not the appropriate claimant because GGM had the interest in the land, and her argument was that this agreement had created a licence.
And we said, well, even if it does, there's an estoppel.
Absolutely, that's what yes. But it was being argued by Miss Leleva that this agreement at that point, this agreement created a licence. Now I accept that for the purposes of the possession claim, that didn't have to be determined because her right of occupation had been granted by G100, and she was just stopped from denying that it had sufficient interest in the land.
Well, she was having G100 having let her in, she was stopped from saying you can't now.
You can't now get me out. Absolutely.
Can I just ask you about the proposition of law, which I think you put to my lord, which was that you can't convict anyone beyond reasonable doubt if a judge earlier on had said the matter was arguable. I mean, there are a whole series of trade description authorities where things have been found to be arguable, and then and then later on there have been criminal convictions when the matter's been decided. In both civil and criminal.
Yes. So my lord, His Honour Judge Luber doesn't say it is arguable.
Yeah.
He says it is a licence.
So it's the degree of certainty that he
Absolutely.
expresses. Thank you.
Yes.
My it is right that the London Borough of Hounslow say in relation to this issue, the construction or the interpretation of the that contract is just a question of law, and therefore it doesn't what's the right word? It doesn't matter what standard of proof you're construing it or determining what nature of agreement it is on. And in my submission, that must be wrong, because there are agreements which aren't clearly one thing or the other on an interpretation, and that's why we come in front of the courts to have them interpreted. There wouldn't be any interpretation cases if every agreement was clearly one thing or another. And on an interpretation, a court might decide one way or the other, but it might be a close run thing.
Well, if we're interpreting a written contract, then that's a question of law.
Yes.
It's not a question of fact which needs to be
No.
proved beyond a reasonable doubt. It's a question of law. So if we are looking only at the property protection proposal, then either looked at in isolation, it creates a license, or looked at in isolation, it creates a tenancy. That's not what the FTT did. The FTT here said, well, it is drafted in language more consistent with a license, but where the language of license contradicts the reality of lease, the facts must prevail. So that's the approach that the FTT adopted.
Yeah.
They then looked at the facts, and particularly the evidence of Mr. Woolgar, and they said, well, and they conclude by saying at 75, on the basis of this evidence, the tribunal concluded.
Yes.
Now, why isn't that good enough?
Well, so my lord, in my submission, the starting point was the agreement.
Well, that's where they did start. See paragraph 69.
And they say that on its face, the agreement is more consistent with being a license than with being a lease.
Well, I think the FTT would agree with you. That's what they say at 69.
Yes. So in my submission, the starting point between two commercial organisations should be the terms of the agreement that they've made between them. The fact that something different happened on the ground doesn't mean that those rights didn't exist and were not enforceable in their terms. So what the first tier tribunal do in effect is fall into the trap that was
That's got nothing to do with the standard of proof, which is what you started with.
no, my lord, it doesn't. But it, in my submission, is because of the first tier tribunal is here considering whether or not criminal liability should be applied to a body, to a company, and we can see from its approach that it was keen to find that somebody was the person managing or the person having control. And the way in which it did it was by considering which one of the parties was most responsible for the situation that pertained on the ground at Stamford Brook House. But having construed the agreement and found that it was in the language of a licence and not in the language of a lease, in my submission, that should have been an end of the matter, and it should have found that it was not a lease. And indeed, my lord, that's what I understand you and your fellow judges to have done in the Laver, G100 and Laver on the possession claim. In relation to the sub-licence. And so My lord, if and insofar as ground 2 is concerned, my submission is that there wasn't, that the first tier tribunal erred in going on to consider the position on the ground when having found that the contractual agreement in effect created a licence.
And what is the answer to the reason that they gave for going on, namely what Lord Templeman had said in Street and Outford?
Paragraph 84, my lord.
469, really.
Sorry.
Because they said, you're right, it looks more like a licence than a lease, but we have to look at, in reality, whether that's true. And having looked in reality at whether it was true, they found that actually it was exclusive possession and therefore a lease.
So
Well,
as
Street and Mountford is...
as Lord Templeman says, you consider the surrounding circumstances, the nature and extent of the accommodation, and the intended and actual mode of occupation of the accommodation. And that's what they did.
My lord, so Street and Mountford is really much more limited, I think, than the first tier tribunal understood. Street and Mountford says just because you call something X doesn't make it Y. And it was conceded in Street and Mountford that the occupiers had been given exclusive possession of the rooms.
Yeah.
So Street and Mountford is not authority for the proposition that you carry out an investigation of what is actually happening on the ground. It's authority for the proposition that just because parties label something as a licence, that doesn't mean it's a licence if what in fact they've done is granted exclusive possession. And my lord, in Street and Mountford has conceded on behalf of the owner that exclusive possession, that the room exclusive possession had been granted.
Yeah.
But it's really AG Securities and Vaughan, isn't it? Which the FTT expressly quotes, as my lord has observed, in the second half of paragraph 69.
I mean, in my submission, AG Securities and Vaughan is really about the circumstances in which the agreement isn't giving effect to what was actually agreed between the parties. So they've got a written agreement, but something else is happening. In my submission, you have to find effectively that the document is a sham. It's that the rights, that there is no intention to exercise the rights that are being granted in the document. And in this case, there is no evidence that that was the circumstances. The NHS PSL wanted their property protected, and that's what GGM were doing. And it's, in my submission, we get into real difficulty if what we're required to do for this criminal liability legislation is look at what's happening on the ground, because that might change over time, meaning that premises that were originally not a house in multiple occupation at their inception become a house in multiple occupation as a basis of the use that is being made by the people who are in actual occupation.
Isn't that consistent with the statutory purpose of protecting those vulnerable? Because if it's changed, you might have set up the most perfect suite of documents drafted across the road in Lincoln's Inn, and on the ground everyone's being exploited just because it changed. You might have run it for a year in accordance with the documents and then created a house in multiple occupation. Why shouldn't?
Well, my lord, in that situation, in my submission, what you're creating is a sham document. What I'm talking about is circumstances in which, let's go back to the live and work, the requirement to live and work in the premises, but nobody's actually working. Everybody's working somewhere else. if we move on to how the Upper Tribunal approached this second issue insofar as the Leleva case was concerned, at paragraph 50 at page 58, I apologise, tab 4. Tab 4 in the main Leleva bundle. Paragraph 50, page 58. Mr. Justice Fancourt says, in my judgment, the FTT was clearly right for the reasons that it gave to reach a conclusion that GGM was a tenant of the property pursuant to the signed proposal, and therefore a lessee within the terms of the 2004 Act. Although the proposal is couched in terms of GGM providing services to the NHS, the reality is that those services were only provided by virtue of GGM having exclusive possession of the property and being able to exploit it for its own gain. First by converting it to residential use and then by licensing up to 30 residential occupiers to occupy all habitable space in the property. Mr. Justice Fancourt effectively relied upon the reasoning of the FTT, and in my submission, for the reasons I've set out, the FTT was not entitled to reach a conclusion that the property proposal did create a lease and not a licence.
Yes, you have to put it that high, don't you? That
I do.
They were not entitled
Yeah.
to reach that conclusion.
I do.
Do you submit that they misdirected themselves in law, or simply that they reached a conclusion of fact which they were not entitled to reach on the evidence before them?
So, in my submission, the reliance on AG Properties and Vaughan was a misdirection of law.
Yes.
Because
Because there was no intention to mislead. The parties weren't trying to mislead each other or anyone else. There was no sham involved, and the terms of the licence as between NHS, or the terms of the agreement as between NHS and GGM were enforceable, and the first tier tribunal found that those terms were consistent with it being a licence and not a lease. The fact they weren't enforced, or the fact that something different was happening on the ground in my submission, doesn't change the position that the contract created a licence. Moving on then to the third issue. The rack rent issue. In summary, what we say about that is that what is the rack rent requires some expert evidence.
Well, can I just look at your ground 3? It's on page 15 of the file. And what you say is the Upper Tribunal erred in finding there was sufficient evidence to find that G100 was in receipt of a rack rent. Is that a question of law at all on which we have jurisdiction to intervene? Or is it a question of fact, whether the evidence was sufficient? You don't say there was no evidence, you say it wasn't enough.
Yes.
Now, why is that a question of law?
My lord, the evidence that was relied upon by the first tier by the Upper Tribunal, I apologise, and by the first tier tribunal, was the amount of money that was being paid, and that GGM stroke G100 wouldn't be doing this at any less than the maximum amount that they could get.
Yeah.
It's our submission that isn't any evidence of the rack rent. But it's what they relied on to establish that it's the rack rent. So I would submit that it's actually a question of law, because there was no evidence of the rack rent.
So you say what GGM received was not evidence of rack rent, and therefore there was no evidence.
No evidence of the rack rent. And
If it was evidence of rack rent, but you say it wasn't good enough, that wouldn't be a question of law, would it?
no. But I think we put it in our skeleton argument that it's wholly circular, which indicates that it isn't any evidence at all. Because what you're saying is, well, this is what you're getting, so that must be the rack rent. And in effect, it isn't. It's a self-fulfilling prophecy, isn't it, my lord, that whatever a company's charging for something must be the rack rent, because that's what they're charging, and they wouldn't be in the business of being beneficent or charging less than the rack rent.
Of course, it doesn't have to be the rack rent, it's only got to be 2/3 of the rack
It
rent.
only has to be 2/3 of the rack rent, but that would require some evidence of what the rack rent is. So, my lord, yes, you're right that what we're saying is that there wasn't insufficient evidence of the rack rent. There was no evidence of the
Yeah.
rack rent.
Can I just ask one point on that, which is, I mean, typically in another area when one's dealing with valuations of buildings, where you have a willing seller and a willing buyer, the amount that is paid is evidence of the market value. Of course, it may be wrong. They may have made a silly bargain, etc.
Yes.
But it's at least a starting point, and therefore some evidence. Whether it's enough, we can understand your point, but is it not some evidence?
Well, in my submission, given the purposes for which GGM was under the head agreement, was granted permission to allow G100 to grant sub-licenses, in my submission, that can't be seen as an open market arrangement. So when you're saying the price at which somebody buys something is some evidence of its value, in my submission, that must presume that's on the basis that there has been an open market sale. So in this case, what we have, and it was recognised by my Lord Justice Lewison in the Ludgate House case, is that the guardianship arrangements are set up so that people pay less than they would do if they were being granted full rights, security of tenure under an assured short-hold tenancy agreement. So in effect, what we have is an arrangement that is deliberately designed to be less than the rent that could be achieved. My lord, your description of, I'm sure you're familiar with it, of sorry. In the Ludgate House and Ricketts case, my lord, paragraph 7, page 133 in the authorities bundle, which is behind tab 7, the first tab 7. I think the only tab 7. The second sentence starts, a property guardian is a private individual who usually with others occupies vacant premise under a temporary contractual licence until the building owner requires it for redevelopment. The arrangement provides for the guardian with accommodation at a lower cost than in the conventional residential letting market. So we know in these circumstances that the price that is being paid isn't the going market rate.
For a conventional letting.
For a conventional letting, absolutely. I accept that. But there's nothing that says in relation to the rack rent that you assess it on the basis of the rights that are being currently granted.
But you could never have an assured short hold tenancy of these buildings because of the way they were configured.
Well, you can, because, and indeed that's what Maria Laleva was arguing, and it wasn't.
But yes, but you have relied on what the courts have
No.
already decided. She argued it, but she failed.
But that was not because these premises were incapable of amounting of being an occupied by assured short hold tenants. It was because the licence agreement didn't grant her a tenancy. So the Housing Act 1988 provides that you can have an assured short hold tenancy where you have exclusive possession of part of a premises and share the rest of the premises with other people. So provided you have exclusive occupation of one part, the fact that you share amenities with other people doesn't make it not an assured short hold tenancy or an assured tenancy. And indeed, there are HMOs where the occupiers are granted tenancies, so they're not all done on a licence basis. So, what the London Borough of Hounslow appears to say in this case is that they were receiving £180,000 a year, £15,000 a month. That's a big sum. It is the rack rent. Really, that's not good enough, is it? There has to be some expert evidence we submit to say what the rack rent would be. And the rack rent could be achieved by the property being used let in other ways. It doesn't have to be the current use or the actual use that is being made of the premises. I accept that it is on the basis of the premises in the condition that they are in, so that you're not assuming that they're going to be improved in any way. But we don't know whether or not a commercial use of the premises would achieve a higher rent or not. And it isn't an answer to the question to say, well, it's probably in the region of 2/3 of what the highest annual letting would be, because, again, we don't know. It's £180,000 a year, therefore it must be with 2/3 of £240,000 a year, which is the rack rent. My lords, those are my submissions in relation to the grounds, unless I can be of any assistance. And I just well, I'm sorry for turning my back. Unless I can be of any further assistance.
Why did you say the Upper Tribunal was wrong on this ground? I don't think you've shown us the FTT, but why is the Upper Tribunal wrong?
I apologise.
The Upper Tribunal dealt with this at paragraph 92, I think. Mr. Justice Fancourt pointed out that if the property was to be let as a single whole, rather than it'll be less than the aggregate of rents for the individual rooms, which is valuation common sense.
So we're going to arrive at a basis on beyond reasonable doubt on the basis of valuation common sense, my lord. I'm concerned about that. I accept that in many circumstances, letting individual smaller parts of a building can result in in a higher yield. But that, of course, is a result, isn't it, of the person who is doing that only being able to make a profit if they pay less for taking the whole of the property.
Well, they've got the cost of managing it for a start.
Absolutely. No, I accept that. You might say that the net rent would discount their costs of, the net annual value would discount their cost of managing it. But in my submission, that isn't enough to establish that it's the rack rent beyond reasonable doubt. And certainly this building would have been capable of other uses. And what was happening here was the proposal by Global Guardians Management to the NHS was that we will save you money by our arrangement, by allowing Guardians to occupy it rather than you having to provide security for it. So the NHS were looking at a situation in which they were going to be spending money protecting the premises otherwise, but we're going to receive, I think it was £600 a month, which clearly isn't the rack rent. But that doesn't mean that another use of these premises, and even another multiple occupancy use, so letting the rooms as offices, might have achieved a higher return. But we simply don't know.
Yeah.
And it was incumbent upon the London Borough of Hounslow to produce at least some evidence of what, some expert evidence of what the rack rent is.
Yes.
Well, those are my submissions. Thank you very much.
James. Thank you very much, Mr. Grundy. Yes, Mr. Bates. You are dealing with ground one only, I think.
I am. I may have a tiny bit to say on grounds two and 3, but it will be in the de minimis territory. I'll be associating myself with Mr. Bowes on that. Dealing then with ground 1, section 254 and the sole use point, I say there are 3 answers to what's been said against us. 1 narrow answer and 2 broader answers. And I'll hopefully get them all done before the short adjournment. Can I start with the narrow answer? And can I start with the statute itself on page 260 of the authority bundle? There are 2 points to make about subsection 2. The first is that it's common ground one has to satisfy all elements A to F. And secondly, it's common ground they were also satisfied, except for D. And that's important, because if you read down the list, in 2C, you see that before we get to D, the logically prior issue is that the living accommodation is occupied by those persons, my clients, as their only or main residence. So in effect, their home. So you don't get to questions of use until you get through that first stage of knowing they're occupying it as only or main residence. Secondly, in D, the focus then is back on their occupation, i.e. under C, their occupation of it as their only or main residence, constituting the only use of the accommodation. But there was a slight, in my submission, detour this morning via mixed-use properties. That we all know mixed-use properties can still be only or main residence, only or principal home. It's always a question of fact and degree. And as my lord, Dingemans, was pointing out in argument, I suspect, with reference to his decision in Cain Laverack in mind, the terms of mixed-use lettings may be critical to determining what's actually going on the ground. The point is, feeds into the third point I'll make, the point is that what you're looking at under 2542, in particular D, is a factual question. What are these occupiers doing with this land that they occupy as their home. And thirdly, as my own friend took you to this morning, but perhaps didn't put the stress on it that I do, D is presumed to be satisfied. The point of section 260 on page 263 is that in all proceedings, in any proceedings, so whether in the FTT, in the magistrate's court, in proceedings for prosecution, it's deemed to be satisfied unless the contrary is shown. So the narrow answer is, if it's a factual question, did Global 100 produce enough material to show that this was the only use of the land? And that must be a factual question to be decided.
This was not the only use.
Was not the sole use, yes. So here, on the narrow question again, well, just look at what they provided. So in the Jimenez decision, if we go to the main bundle, in Jimenez, page 74, you see at paragraph 19 that global, I'll use them interchangeably for the moment, it's only Global 100 I'm concerned with, because Global 100 is the only entity against whom I obtained a rent repayment order. But Global's appearance before the tribunal was simply by its solicitor, no oral evidence called, and as the tribunal canvassed with the solicitor, see paragraph 27, he wasn't there to give evidence. He was there simply to provide legal submissions. I don't criticise him for that, that's obviously right. So they put their case entirely on a submission based on the paper materials to do with their agreement.
Well, they would say it's clear from the paper materials that the reason why the Guardians were in the property was so that GGM/G100 could provide the Guardian services for the NHS.
But then one comes back to where I was 5 minutes ago. Question of fact to be rebutted. The trial tribunal is obviously the primary finder of those facts. It's entitled to find that's not enough. And that's all this case amounts to. We say this in our skeleton. Global's real point here is that they say their contractual arrangements mean they can never fall foul of licensing. Their arrangement is bomb-proof. There is no scenario in which you can catch them. Because their entire cases, look at the documents are enough. And our answer to that simply is, if this is a factual question, as we say it is, it can't be the position that the documents are in and of themselves always the complete answer. It must always be a finding of fact based on the entirety of the available evidence. And slight deviations in the evidence may lead to slight differences. To put it another way, the tribunal's conclusion at paragraph 45 on page 78 can't possibly be a factual finding that was not open to them in any circumstances. Unless you accept that this contractual arrangement has achieved what Global says it has achieved, which is to take them outside the scope of Part 2 licensing for all purposes and for all times. If I am right that satisfying 254D is a factual question, then a document created in the abstract can't possibly have that effect for all time, for all purposes. It's a similar answer, respectfully, in the Labour appeal. If we go to the second main bundle, in the Labour appeal, the one with Hounslow, at page 112. Now this time Global took a slightly different approach.
Just hang on a minute, let me get the right bundle out. Labour core bundle, page 112.
Page 112, yes.
Yes.
So this time, if you look at paragraphs 29 to 31, a different approach was taken. This time witnesses were tendered. 29, the witness described there produced a detailed statement that the difficulty was, as the last sentence recalls, her evidence couldn't be tested in cross-examination, and the reason for that is explained earlier in the decision. She'd fallen ill. So a replacement witness was tendered, effectively to speak to the truth of her statement, paragraphs 30 and 31. And the answer is in paragraph 31. The replacement witness simply did not have sufficient knowledge of the subject property to be able to deal with the questions which the tribunal and the parties wanted to put. Now again, they're right to call some evidence, and they're right to call evidence because it's a factual question. All that happened is their evidence didn't achieve what they wanted to achieve. The answer for Global, if I may, is in future cases lead positive evidence about actual use. It's not to try and say that these findings are never open to the tribunal, because there are no circumstances in which one could ever go behind the contractual terms that they negotiate with the companies to whom they provide the services.
I think that the case for the appellant is straightforward. It may or may not be right, but it's certainly straightforward. I think they say that it doesn't require analysis of particular evidence in any individual case, because on a proper objective analysis of the arrangement, there is more than one use here. The inherent nature of the occupation by the Guardian is that it is not only for residential, and it is that the whole point of the arrangement is that they are there to guard.
So let me pick up on that, because the two answers to it, and it segues into the first of the broader answers I wanted to give. The first answer is coming back to my narrower point. Section 260 is plainly envisaging in my submission actual evidence of individual use in each case in order to rebut the presumption that Parliament has put forward. It's not envisaging a class whereby this could never happen. The way to take classes out of HMO licensing, if you're so inclined to do, is to pass statutory instruments exempting classes, as the Secretary of State is presently trying to do, as I'm sure you all know from reading the press, with certain classes of asylum seeker accommodation. It's not by reference to a single document that has the effect of always meeting the duty to rebut in section 260. But the second answer to my Lord's question, and it's coming into my first of my broader points, is that depends entirely on you equating use and purpose. And when we looked at 260, it was my client's use we were looking at. Just going back to it, their occupation, and that's their occupation under C, i.e. as their only or main residence, their occupation constitutes the only use of the accommodation. So, the answer to this, we say, has been given convincingly by the Upper Tribunal in Jimenez. And if we jump back to that bundle, page 40, I'll just speak to the Deputy President's answers to that criticism or that point. It says paragraphs 45 down to 49. So one doesn't equiparate use and purpose. For the first reason, in section 45, in paragraph 45, he gives that this is effectively a form of public health statute. It's about ensuring that occupiers are entitled to certain minimum standards in relation to the property they occupy as their homes. The answer to that doesn't depend on the term of the contract. The answer to that turns upon the objective use to which the property is put. He makes the same point in paragraph 46.
So if you and your colleagues started sleeping in chambers, that turned it into an HMO?
No, because you'd fail C. Wouldn't be only your main residence.
Well, it depends whether you had somewhere else to go.
There is a possibility, I put it no higher than that, there's a possibility that unlawful user might fall to be excluded. You can well imagine situations where someone has, in breach of a contractual or statutory obligation, sought to create an HMO. Then you might have all the line of cases about seeking to take advantage of your own wrong, etc., etc. But what you're looking at in my submission on 2542D is how are the occupiers using it, which is an objective question, identifying their use of the land, and more importantly, it's 260. It's presumed to be satisfied unless that's rebutted. That's why I keep coming back to the need to leave proper factual evidence about what's going on the ground. Whether we're in the Magistrates' Court or the FTT, we don't concern ourselves with 2542D unless someone advances a positive case that it isn't met and must logically, therefore, lead the evidence to support that positive case. That's why, I've said it 3 times now, you've either got it or you haven't. That's why it comes back to, what did they produce? The tribunal looks at the documents, it hears from the occupiers. In some cases, not this because of the COVID restrictions, it may do a site visit. It will no doubt have all manner of other evidence to look at. In one of the cases, there's a local authority inspection note that's referred to. That's the kind of multifactorial analysis the tribunal takes on to decide what the use of the property is. We don't say, and we accept this in the skeleton, we don't say terms of the agreement are always irrelevant, but they're simply one factor that goes into the mix in deciding what the use is. And that takes me to paragraph 47 of Mr. Rogers' judgment, again, which we wholeheartedly support. He doesn't exclude the relevance of the licence agreement terms. He simply says, well, they don't prove as much as you seek to establish they prove. All they show is that the guardians, my clients, are required to sleep on the premises for 5 nights out of 7, not permitted to leave the property empty, and to inform in respect of unauthorised access. They mustn't conduct businesses or hold meetings, but the only thing they're positively entitled to do is use it as their main residence. And if I may just segue out of paragraph 47 for a moment here. In their written submissions, less so orally, but in their written submissions, the appellants place very heavy weight on the security aspect provided here. Both tribunals below formed the view, in my submission rightly, that there's a very minimal security element here. And they were right to do so. If you look at paragraph, if we go into the Jimenez supplemental bundle, and in the Jimenez supplemental bundle, page 112, we have a sample licence here. You'll see paragraph 11. My clients had no security responsibilities as defined in the Private Security Industry Act 2001. We'll come back to that in a moment. And we only have the powers of an ordinary citizen and will not assume powers of a security officer or any police or governmental organisation. The Upper Tribunal picked up on this going back to the Jimenez core bundle, page 37, paragraph 29. Well, for completeness, paragraph 28 as well, but particularly 29. The reference to security responsibility or authority as defined in the Private Security Industry Act in 2001 is obscure, as a perusal of the Act does not reveal a definition of either term. Schedule 2 of the Act does contain a list of activities of security operatives, which is an offence for a person to engage in the course of any employment without first obtaining a licence under the Act. These include guarding premises against unauthorised access, guarding property against destruction, damage or theft. The extent, if I may be so bold, of the obligations that were on my client to provide anything that might be considered security related is back in the supplemental bundle at page 107. And it's paragraph 4.10. Our obligation is to inform G100 if we become aware of damage, risk of damage, or any person attempting to gain access without the permission of G100 or the owner. So via that detour, coming back to what Martin Roger KC, the Deputy President, said, main bundle, page 40, his paragraphs 48 and 49, he's quite right to describe security as a happy byproduct. It's a byproduct arising out of the use. It's their use of the land as somewhere they will live for 5 nights out of 7 that has this consequence, but it's not a use of the land. The use is as their only or main residence.
Did you submit that, in a sense, the use of the language of purpose is not really helpful in this context?
Great.
Because the true distinction may be between use, square brackets, if you want, you can use the word purpose, close square brackets. Contrast that with side effect. And what was really going on here, objectively analysed, you say, was just one thing, which was these individuals were living in this room as their only or main residence. And the whole point of the arrangement was that by their living there, that had the beneficial side effect from Global's point of view, that it also rendered the premises secure. Is that what it comes down to?
Yes, the last sentence perhaps goes slightly too far, because of course their presence in and of itself doesn't render it secure. They are not security guards providing security services.
I understand that. It is less likely to be vandalised, squatted in, for example, because they are living there.
Quite. An undesirable outcome is less likely because they are living there. but the purpose, when we look at the use, to come back to the statutory language, the use is as their only or main residence, and that's all they use it for. They don't run businesses from there, they don't conduct meetings. They sleep, eat, cook. They live there. And then, again, at the risk of repeating myself, the way Global approached the appeals in this case was simply that they didn't have evidence to rebut that presumption. I said I had two broader answers. That was my first broader answer. The Deputy President was right for the reasons he gave. The second broader answer relates to more general questions of policy. We said in the skeleton, frankly, this is a make-weight. The words mean what they mean or they don't. But the policy here is important, and the Deputy President was right to identify it in Jimenez. So if we go to Jimenez, paragraph 13, the Deputy President takes us through now the very known tour through earlier cases under what was the Housing Act 1985, which used to regulate these provisions. Brent and Reynolds, and then Rogers and Islington. So Brent and Reynolds, the indented paragraph at 13. Description here, which largely, but not completely, fits with the facts of this case. HMOs are or are usually domestic premises originally designed for occupation by one family, converted for occupation by a number of separate families or individual. The process, which almost invariably involves the sharing of bathrooms or kitchen facilities and the use of parts of the premises for purposes which were not originally designed, raises obvious potential problems in terms not just of the amenity, but the safety of the premises. Parliament has seen fit to make special provision. We don't need to go through it all now, but I mean, depending on how far back you want to go, you can go back as far as Victorian public health legislation and the regulation of lodging houses to trace all the evolution back. But certainly HMOs since the mid-50s.
Given the presence of C, that it has to be only or main residence, what is the purpose of D?
So Mr. Bowes touches on this in his skeleton, and I hope you won't mind me saying that he's largely lifted this from the commentary in the Encyclopedia of Housing Law. But the problem, commentary for which I may have to be updating depending upon how this case goes. The problem is, you go back to how it used to work under the Housing Act 85. And under the Housing Act 85, the question under the previous legislation was simply, was the house occupied by persons who do not form a single household? And so one of the things that had happened is that large numbers of things that it was considered undesirable to be caught had been caught. So, for example, next to one of these...
Hostels and that kind of thing.
Hostels, a house fitted out for children to reside in the summer months, a religious retreat, a huge number of things had just been found to fall within the definition. And so one thing the 2004 Act does, consciously, is move away from that definition in the 85 Act, which itself had legacy provisions earlier where, and comes up with this new test here. It is possible, it seems to me, that you could have a property that was your only or main residence, but where the sole use was not as a residence. You may have some of the more complicated, factually esoteric, live and work units, depending on the situation there. It's providing a get-out clause because having changed the definition so significantly from 1985, because 1985 had been considered to be far too broad, that's the best I can come up with in terms of an answer. The explanatory notes don't help us. What was the Holmes bill before the election doesn't help us with this bit here. It simply seems to be a reaction to the view that the 85 Act had gone wrong, and so a different approach was being taken.
Mr. Bates, can I ask you about a slightly different point, but on this topic of the underlying social policy?
Yes.
Its use in construing the legislation. But could it be said that there is a social policy which might pull in the other direction, which is to enable people who desperately need somewhere to live to have somewhere to live, and that if this is construed in the way that you're submitting it should be construed, it will simply have the effect that people will not make these kinds of arrangements, and therefore these individuals who at least have somewhere to live in what were perhaps commercial premises which are awaiting conversion or demolition. And they know, and the point is made against you, they do it with their eyes open, that they're going to get something less than the market rent they'd have to pay in a city like London otherwise. I mean, is that a proper consideration for the court to have in mind?
May I answer that by first answering a slightly different question and then coming back to that? Because we do have in the bundle of materials the government's most recent admittedly non-statutory, but the government's most recent publication concerning property guardians in the authorities behind tab 6. Oh, sorry, the second tab 6, sorry, you're quite right. In the other section 6, it's page 227. Now, just take you through some of this. Paragraphs 3 and 6 make the point I've been just making about the standards generally being lower. You see in paragraph 3, guardians can be asked to live in conditions that do not meet the standards expected in residential properties. And 6, all buildings used for residential purposes must meet housing safety standards. Local authorities have a duty to keep conditions in their area under review, identify actions that may need to be taken, include properties occupied by property guardians, but because the properties are not generally designed for residential use and may be adapted, some buildings may be especially hazardous or dangerous. 11, the description of the kinds of properties that are covered. And then after a bit of a run through some of your rights, 34, I should probably draw your attention to. Because 34 seems to me to be the government's view that it must at least be possible for these properties to be licensed. When moving into a property guardianship scheme, sorry, it's page 243, I've jumped ahead. When moving into a property guardianship scheme, check with your local authority whether the property is licensed as it should be and that it's compliant with those licensing conditions. So, to then come back and answer my Lord's question, to the extent the government has a view, it seems to me to be paragraph 3 on page 229. You have a right to live in these properties if you wish to, because you have a right to make informed decisions about your housing choices. But at the same time, there are certain standards below which one must not fall. Now, the extent to which the court gets involved in balancing those considerations, well, that becomes a much trickier question. There is authority from this court. My Lord Justice Lewison will know it well, because it was decided against me, which is stressing the primacy of the local authority's decision-making role under much of the statute. The context is different. It was to do with fit and proper persons and their assessment as to who's fit and proper. But as it's generally the enforcement authority, as it has the statutory responsibility for its area, as it is under a duty to survey the stock in its area from time to time and take appropriate action, that would suggest, in my respectful submission, that the court should adopt more of a hands-off approach to this. It's a pure statutory interpretation question. Do you fall within 2542D? If yes, there are consequences. If no, there are not. It's not irrelevant, though, to note, as is plain from the facts of this case, that guardianship schemes generally involve lower quality accommodation. That's the point of the deal. I simply say there are standards below which one is not allowed to fall. If you are an HMO, Part 2 licensing is the standard below which you are not allowed to fall.
Can I just, flowing on from that, turning to a slightly different issue, can I invite your assistance, please, with a submission I think that's made on behalf of the appellant, which is based on the presence of section 255 of the statute. I think the submission amounts to this, that you shouldn't be striving to give a broad interpretation to section 254 2D, because in a given situation, the local authority can make an HMO declaration even where the sole or significant condition isn't met. Sorry, the sole condition isn't met, provided the significant condition is met.
So I think the answer to that is found partly in what I just said about the policy change from the old 85 Act, and then it's explained by the annotations, by the commentary in the supplemental bundle of authorities behind tab 5 at paragraph 6, at page 16. We have the explanatory notes on 255. And the examples of properties, I'm aware, of course, of all the caveats on the use of explanatory notes, but the properties that are given there as examples of situations where you may want to use 255 is precisely to catch again the kind of properties that it was thought the 1985 Act had wrongly called, i.e. hostels, hotels, etc. So what 255 is there to do is to let authorities that want to go back to the 85 Act position. It's not a legitimate aid to what 2542D is meaning. It's recognising that some authorities, for reasons to do with their own local area, may have preferred the 85 Act regime, and that's how you keep it. Might I just very briefly on grounds 2 and 3? I'm not sure ground 2 affects my clients at all because we have no remedy against GGM. Our rent repayment orders were only against Global 100, and following the Supreme Court decision in Rackerson, we could never have got a remedy against Global Guardian Management anyway because we're in no direct contractual relationship with them. But I simply say, because it's asserted in the skeleton argument, there's an estoppel of some sort that binds us, or binds 7 of my clients, I should say, from the Laleva case. We've put it in the skeleton. It seems to us, respectfully, both the district judge and Judge Luber on appeal were dealing only with arguability threshold tests rather than a finding in rem to bind certainly the 4 who weren't parties, and perhaps even to try and bind Hounslow. You were dealing with a different question, but I wasn't in the case. My Lord Justice Lewison decided it. I'm sure he knows much better than I do what they thought they were deciding. I simply note, just for your pens, in the Laleva Upper Tribunal decision, paragraph 26, the Upper Tribunal appears to have read it the same way that we did, that it didn't make, there are no findings that are relevant here. It was an arguability test. Otherwise, I'll leave Mr. Bowes to deal with that. And then briefly on issue 3, I was going to make a point about licence fees being included, but now that's been conceded, that falls away. So I just make 2 very, very brief points about rack rent, and then I'll leave Mr. Bowes to develop these after the adjournment. The first is, of course, that one of the points my learned friend didn't grapple with in his submissions is that we're in front of the first tier tribunal property chamber, who, in another guise, set the private sector rents. If you are a landlord and tenant in dispute over your rent under an assured or assured short-hold tenancy, you can apply to the tribunal under Section 13 of the Housing Act 88 to have it set the rent. It's fully, the whole point of litigation, I was saying, this tribunal, is you're dealing with that expert body, that knowledge of local circumstances.
It is fair to note that normally they do have the benefit of expert evidence before they set the rent.
Well, it depends. The days of each side turning up with surveyors to argue it are long gone. But I would generally, the standard directions nowadays are things like if there are any adverts from the local press you want to rely upon. So they have something to rely upon, I would agree. And secondly, just again for your notes, because I know Mr. Bose wants to develop this, there was evidence given to in the first tier tribunal about the rents here. It's in the Hounslow Laver case. Just for your references again, page 126, paragraph 79. The tribunal records that it heard evidence from my clients.
Page 100 and?
126,
Yeah.
paragraph 79, records it heard evidence from clients about the different rooms that were available, the different rents for them, how that related to, in some of their cases, other experiences of being guardians. So it wasn't operating in a complete vacuum. My lords, just forgive me for one moment. My lords, unless I can help you with anything else.
Thank you very much, Mr. Bates. Mr. Bose, do you want 5 minutes now, or would you rather start at 1 to 2?
My lord, if I can start at 2 o'clock or 5 to 2, then I can hopefully shorten matters.
Right. All right. 5 to 2.
Right.